Good morning, everyone, and welcome to today's virtual tech policy talk at the Center on Science and Technology Policy at Duke University. I'm Matt Peralt, the Center's director. Housed within the Science and Society Initiative in the Sanford School of Public Policy, the Center on Science and Technology Policy focuses on developing concrete, actionable policy frameworks that can be used to improve our experiences with the tech products in our lives. Our guest today is Assistant Attorney General Makan Delrahim, who has led the Antitrust Division at the Department of Justice since September of 2017. He's joining us on his last day in office. He assumed this role at an inflection point in antitrust when new voices in the field were advocating for rethinking the core tenets of antitrust jurisprudence. Against that backdrop, he opened the department's review of the big tech firms, which culminated in the department's lawsuit against Google. He also led the first revision of the vertical merger guidelines in 36 years, secured consent decrees in the Bayer Monsanto and Sprint T-Mobile mergers, and spoke regularly about the application of antitrust law to unique features of the tech sector, such as zero-price products, big data, and nascent competition. Finally, on a personal note, I've always been struck by Assistant Attorney General Delrahim's openness and curiosity, his willingness to engage in dialogue with people of differing views, and his support for new voices in the field. If you need evidence that his commitment to lowering barriers to entry and encouraging nascent competition is not just an abstraction, you can find it in his decision to spend a portion of his final day in office with a tech policy center that was launched less than 18 months ago. Thank you for your service, Assistant Attorney General Delrahim, and thank you for joining us today.
Thank you so much for that introduction, Matt. I appreciate your kind words. I very much appreciate the time we have spent together discussing these issues near and dear to both of our hearts, including at the Council of Foreign Relations this past summer. I'm also grateful to Duke University and Duke's Center on Science and Technology Policy for the privilege of being with you today to share some of my thoughts about the future of antitrust policy. As you noted, this event's a very special one to me. Today is my last day as the Senate confirmed Assistant Attorney General for the Antitrust Division. It has been an immense honor to serve in this role and to lead the great men and women of the Antitrust Division through this time of intense scrutiny around antitrust policy. I think that scrutiny is going to remain and only intensified over the next few years. I would also like to recognize that yesterday we celebrated the legacy of Dr. Martin Luther King Jr. Let us remember that his struggle and lasting message of peace, justice, and freedom included express hope for economic justice and economic freedom. Indeed, Dr. King once noted that, I quote, "Philanthropy is commendable, but it must not cause the philanthropist to overlook the circumstances of economic justice, which make philanthropy necessary," end quote. Those are important words, and it's one where each day we must remember as we deliver economic justice. Leading the Antitrust Division, I take pride that the division plays an important, if sometimes indirect, role in ensuring such justice, and that our day-to-day work helps preserve incentives to innovate, work, and start businesses to the benefit of all consumers and laborers alike. I'm also proud that the legacy of the Antitrust Division includes two former esteemed Assistant Attorneys Generals for Antitrust, Robert Jackson and Tom Clark, who had individual roles in the long arc of the moral universe when they cast 2 votes in the unanimous decision of the Supreme Court in Brown versus Board of Education. I should also note that Tom Clark later served as Attorney General, also integrated the Justice Department's attorney ranks in 1946 with the hiring of Maceo Hubbard as the first Black attorney at the Department of Justice. Some of you may have read that I started my career as a patent lawyer. When I pivoted to antitrust, it was more of an esoteric specialty. While John D. Rockefeller and Standard Oil have rightly earned their places in American business history, few had a true appreciation of antitrust as a discipline that polices the industrial relations of firms for the betterment of consumers broadly defined. Today, antitrust is at the forefront, spurred by the social, political, and economic crises of our time. Today, we're all participants in a spirited public discussion about the goals and limits of antitrust. In many ways, 2020 was an inflection point in that conversation, and perhaps a signal that we have pivoted from discussion to action. Last fall, we saw the filing of historic lawsuits by the government against Google and Facebook. A few months before, the House Antitrust Subcommittee of the House Judiciary Committee released a landmark report on market power in the digital markets. Additionally, Congressman Ken Buck, joined by others, issued a separate report called The Third Way, addressing their concerns of the competitive deficiencies in the technology marketplace. These important events reflect sustained bipartisan interest in antitrust issues. Undoubtedly, I have had a unique perch from which to participate in and observe this critical period. Over the last 3.5 years, I've wrestled with difficult civil and criminal enforcement decisions, overseen victories and painful losses, witnessed the promise of public and non-public investigations, while being inspired by the tenacity of the division staff, and engaged antitrust thought leaders with whom I agree and many with whom I vigorously disagree. This work has challenged me in important ways. On some matters, I have reassessed certain intellectual priors and reconsidered arguments that I once thought out of the question. I have retreated to first principles to explain why some fashionable policies would be bad for consumers. I have stretched to consider whether worthy welfare goals could be achieved by better means. Most consequentially, I have asked and empowered the men and women of the Antitrust Division to approach problems, both big and small, differently, and they have had the grace and intellectual vigor to consider those directives. The transition of power is an important opportunity to share lessons and insights, because regardless of politics, I root for the success of this great institution and for its forthcoming stewards. In addition to being available to them in any way that I can, I want to share some of my considered conclusions with the public, a testimony of a kind to the policymakers in Congress and both domestic and international antitrust enforcers who will lead through the next few years. I hope these suggestions will make enforcement more administrable, empower consumers, and offer increased clarity to businesses, both established and the ever important startups. I offer two major theses. First, antitrust enforcers and policymakers can continue to do more to accomplish reliably the results that our traditional effects-based analysis dictate. Thoughtful legislative changes can effectuate these goals. Second, some of the current debate about online platforms and digital markets is focused on principles that are foundational to trust in a market-based economy. We should consider many of these goals as preconditions to healthy competition, but not one and the same as the need to police the rules of merits-based competition. Policy solutions have ranged from direct command and control regulation by creating yet another regulatory agency to oversee the digital technology industry, to wholesale calls for breakup of companies who reach a certain size, or to more laissez-faire self-regulation by industry itself. The events of recent days have laid bare the extraordinary influence of technology giants in matters of public policy. But if we don't find a way to harness that power into partnership with democratic policymaking, we risk devastating outcomes for our civil democratic society. Today, I suggest a possible different model, a hybrid public-private rulemaking body with limited government oversight to advance the goals of increasing consumer trust in online platforms. This design will benefit from positive incentives and harness the ingenuity and technical expertise of our greatest innovators. This body also could implement rules that products and services should not face discrimination from platform operators, either on the basis that they compete with another product that the platform operator provides, or on the basis that they espouse viewpoints inconsistent with those of the platform operators. First, let me get into some legislative reforms. Congress serves two important roles: oversight and lawmaking. Rooted in the separation of powers, our system works best when checks and balances are robust. While the executive and judicial branches have been active, the public is best served when Congress uses the power allotted to it by the framers. As the first article of Constitution, its importance cannot be overstated. The 116th Congress made great strides for the advancement of antitrust enforcement. Undoubtedly, one of the more consequential events that coincided with my tenure as AAG was Congress in both chambers using its oversight, including subpoena power, to investigate market power in digital markets. That work culminated in a body of public record and the issuance of the House report summarizing the Antitrust Subcommittee's findings and recommendations. While I believe some of its suggested reforms require further consideration and further exploration, some reforms are quite sensible. On the legislative front, I was extremely pleased that Congress passed and the President signed into law several important antitrust reforms that will strengthen the Antitrust Division's efforts to enforce the laws. We had successfully led the effort to advocate for the permanent enactment by Congress of the Antitrust Criminal Penalty Enhancement and Reform Act and the Criminal Antitrust Anti-Retaliation Act. These tools will strengthen the division's ability to deter, detect, and prosecute cartel offenses. Also, just last week, the Comprehensive Health Insurance Reform Act repealed the McCarran-Ferguson Act's exemption of health insurance from the federal antitrust laws so that the antitrust laws can be brought to bear on the business of health insurance. This important amendment is consistent with a priority of my tenure, interpreting antitrust exemptions and immunities narrowly, as evidenced by my oral argument against a broad interpretation of McCarran-Ferguson before the 11th Circuit earlier this year. Ultimately, this revision will bolster competition in health insurance markets to the benefit of American patients and healthcare providers throughout the country. I'm most proud that Congress saw the need for additional resources for the Antitrust Division. Despite rising costs, shrinking headcount, and more resource-intensive investigations, funding effectively has decreased each year for at least the past 10 years. The recent omnibus appropriations bill contained the first enhancement to our budget in more than 10 years. This represents one of the most important pieces of support for the antitrust mission to allow us to hire additional staff that we need to effectively enforce the laws. I hope that the new Congress will also consider and pass bipartisan legislation to bring merger filing fees current with inflation and consider allocating some of those increases to the divisions and the Federal Trade Commission's enforcement budgets. These latest developments enhance the division's ability to carry out our mission, but more should be done. Congress would be well suited to consider immediately some simple legislative reforms to improve the predictability and efficiency of antitrust enforcement to make consumers better off. I offer 6 recommendations for Congress to consider this term. First, Congress should pass legislation to introduce bright line rules and alter the burdens of proof in civil merger cases in order to effectively combat the excessive market concentration that occurs in some markets. This recommendation is grounded in the division's actual experience investigating and challenging the Sabre Fair Logics and the Visa Plaid mergers in court. In Sabre, the division painstakingly proved, and the court noted, that the actual anti-competitive effects of the deal as reflected in the ordinary course documents, but nonetheless leaned on flawed legal and economic principles to find for the defendants. This is just one illustration of why the courts need additional guidance in these cases. The division's competition policy and advocacy section has been working over the last 2 years to carefully draft burden shifting legislation to advance consideration of this issue. The proposed legislation would amend the Clayton Act to address acquisitions of nascent competitors by dominant firms, specifically for firms with more than 50% market share in any defined market. There should be a presumption that further acquisitions in that same market are anti-competitive, which can be rebutted by the merging companies if they can show by a preponderance of the evidence that the merging parties' combined post-transaction market share would not be able to exercise market power, or that the anti-competitive effects of the transactions are insubstantial or outweighed by the pro-competitive benefits of the transaction. The presumption should apply regardless of the size of the target acquisition, helping to address situations in which dominant firms engage in acquisitions of smaller firms to maintain and solidify their market power, not by superior business acumen, but by acquisition. The government, under this proposal, would still bear the burden of defining the market in which there may be substantial lessening of competition. And the government would have to proffer the merged firms' shares in that market. The existing legal standards on these topics, such as market definition efficiencies, would remain unchanged, facilitating administrability and predictability. My goal is to create a bright line rule for parties and for courts, allowing for better business planning by private parties and better litigation planning by the federal antitrust enforcers. Second, I urge Congress to provide much needed clarity on the reach of the Supreme Court's 2018 decision in Ohio versus American Express. The law that has developed as a result creates confusion and may result in uncertainty and unnecessary litigation for businesses. The issue on appeal was how to prove Section 1 liability for two-sided transaction platforms like credit cards, where merchants and store owners are on one side of a platform run by American Express and customers are on the other. Credit cards, of course, are just one type of two-sided transaction platform. Under the majority opinion, certain digital platforms may qualify as two-sided markets as well. The Solicitor General's brief explained that to show behavior is illegal, plaintiffs should have to prove harm to only one side of the platform. If the platform wants to rely on offsetting benefits on the other side, the defendant should bear the burden of proof. Instead, the court's opinion requires the plaintiffs to not only show harm, but to somehow preemptively disprove that there are benefits anywhere else on the platform. The American Express decision, in my view, obfuscated the legal standard in rule of reason cases. Among other things, it incorrectly raised the standard for plaintiffs to prove antitrust cases by paving the way for defendants and courts to wrongly assert that every market is a two-sided platform. This is a classic example of bad cases leading to bad law. In only 2 years, we already have seen many defense arguments and confused decisions by lower courts, including in the division's case to block Sabre's acquisition of Fairlogics. For these reasons, amongst others, the opinion has been widely criticized and recognized as creating a significant barrier to antitrust enforcement against platforms. In my view, legislation should codify the approach to two-sided markets as reflected in the department's brief and largely adopted by Justice Breyer in his dissent. Specifically, Congress should consider allowing a plaintiff to establish prima facie violation by proving harm on only one side of a multi-sided platform, and importantly, allowing pro-competitive benefits on either side of the market, but place that burden of showing such benefits on the defendant. Third, Congress should repeal the two Supreme Court decisions, Illinois Brick and Hanover Shoe. These decisions work together to confuse antitrust damages doctrine and to handcuff most victims of anti-competitive conduct with no path for recovery, while providing some plaintiffs with an unfair windfall. The Supreme Court in Hanover Shoe in 1968 held that an antitrust plaintiff could recover damages from overcharges, regardless whether those price increases had been passed on to consumers further down the distribution chain. 9 years later, in Illinois Brick, the Supreme Court prevented the proliferation of damages post-Hanover Shoe, holding that only direct purchasers of goods or services from an antitrust violator can sue. Together, these decisions have long been criticized as unfair to consumers who are frequently victimized by upstream cartels affecting products, such as cartels that were enforced by the division in LCD glass screens or auto parts, whose increased prices are passed on into the products that consumers ultimately buy. Legislation should overturn both of these decisions in order to allow purchasers, whether direct or indirect, to also recover from harm caused to them by violations of the antitrust laws, as contemplated by the explicit text of the Clayton Act. Consistent with the recommendations of the Bipartisan Antitrust Modernization Commission, this legislation would improve judicial efficiency by allowing related direct and indirect purchasers to be removed and consolidated into the same court. The legislation would also ensure fairness by allowing defendants in private suits to present evidence that some or all of the damages alleged by a given plaintiff were passed on to other persons in the value chain. Fourth, Congress should consider a modernized pay scale for the attorneys and economists of the federal antitrust agencies. This pay scale does not need to be bespoke, but modeled after one successfully already in use at the Securities and Exchange Commission. The simple truth is that there's great competition for the technical expertise of antitrust attorneys and industrial organization economists at both antitrust agencies. Such a change, in my view, is well justified and would ensure that the agencies are able to both retain and recruit top talent, especially as they compete with a handful of dominant technology firms for the same talent. I would suggest, however, that with the salary structure, Congress demand performance accountability by requiring that employees who are rated in the bottom 5% are dismissed annually. This would ensure that the public who fund those agencies are receiving the best returns for their investment in their enforcers. Fifth, Congress should consider authorizing the placement of antitrust experts at the US missions in Beijing and the US mission to the European Union in Brussels. In an interrelated world, antitrust enforcement increasingly is an international mission. Today, there are nearly 140 antitrust agencies around the globe. The Department of Justice spends considerable resources engaging with our enforcement partners on cartel, merger, and conduct enforcement almost on a daily basis. Given the importance of China and the European Union to the US and to the global economy, it would benefit both US enforcers and the US economy for the Department of Justice to have permanent attachés to focus on competition issues in those two regions. This can also be achieved if these two positions would be authorized to detail to the two regions through an agreement with the Office of the United States Trade Representative that already has missions in each of those regions. Finally, Congress should consider and implement pilot or a specialized antitrust court to hear government enforcement actions, a view echoed by one of my predecessors turned legendary professor and Court of Appeals judge, the Honorable Doug Ginsburg. When the government brings an enforcement action to stop an anti-competitive merger or remedy anti-competitive conduct, we sometimes have been confronted by generalist judges who lack experience with antitrust law or economics. Some have even voiced discomfort with the idea of deciding a case because antitrust law often deals in the counterfactual, the but-for world, such that courts must make informed predictions about the future through a, quote, crystal ball. As a result, antitrust enforcers devote significant resources to educating courts. An exercise that is sometimes wasteful, may lead to trial delays, and is ill-suited for rapidly evolving industries like the technology sector. Even companies find it difficult to police their conduct and M&A strategies in this framework, thereby undermining the deterrence goals of antitrust enforcement. For that reason, a specialty district court where the government can bring civil antitrust cases may be a solution. This court would be modeled on FISA, the Foreign Intelligence Surveillance Act court, with judges selected by the Chief Justice of the United States among interested and experienced district court judges already serving across the country, who can further develop antitrust expertise and help expedite antitrust cases. Yet, unlike FISA courts, proceedings and decisions, of course, should be open to the public. Above all, these 6 reforms are legislative solutions that could improve predictability for enforcers and businesses and reduce waste while expanding transparency and avoiding error costs. Next, I'd like to discuss a new paradigm as a solution for improving the conundrum of concentration and monopoly power in the digital markets. The single greatest issue facing my successors, the new Congress, and the public relate to concerns of market integrity and market power in the increasingly concentrated digital marketplace. These issues include data portability, non-discrimination, and interoperability of digital products and services. There's a groundswell of academic and agency proposals that contemplate direct regulation of firms in digital markets. For example, European Commission Vice President and Competition Commissioner Marguerite Vestager recently unveiled 2 new legislative packages that expand the tools available to restrict the power of digital platforms. I commend this fresh thinking and the work that our colleagues in Europe have done to propose specific guardrails on companies that serve as gatekeepers to many digital marketplaces. Advanced economies require vital preconditions for the success of competition regimes. Among them, rule of law foundations, durable property rights, and public confidence in tangible rights, such as privacy and data security, to enhance free and open markets. As Congress contemplates action, we must strike an appropriate balance between incentives to innovate and protect consumers who participate in the digital economy. Without consensus and a global unified approach, we risk a race to the bottom where neither goal is achieved. Today, I announce a proposal for Congress to consider for a new digital oversight model, a hybrid approach that harnesses the benefits and efficiencies of both self-regulation and government oversight. This would be the Digital Markets Rulemaking Board. This would be an alternative to rigid and direct regulation through traditional regulatory agency models that Congress has enacted in the past to address market failures or natural monopolies, such as through the Federal Communications Commission, or the FCC. Operating alongside current federal privacy, antitrust, and consumer protection regimes, the proposed DMRB would supplement these regimes and in appropriate places preempt inconsistent state laws. With almost 45 years of experience and experimentation The Municipal Securities Rulemaking Board has proven to be an efficient way to achieve the objectives and challenges of certain markets within the securities industries. Congress established the MSRB to address issues of market integrity in the municipal bond market. What I propose today is similar in structure. Specifically, Congress would establish and empower the DMRB to have certain generalized mandates to address market integrity and have sufficient flexibility for the DMRB to respond to rapid changes in the digital marketplace. The DMRB would operate based on the view that private standards of behavior established in conjunction with public involvement and oversight and enforced by a federal enforcement agency can more effectively address the market-related concerns in the rapidly dynamic and rapidly changing digital marketplace. The proposed DMRB's market-focused mandate would prevent the DMRB's mission from becoming, in the words of Nobel Prize-winning economist Jean Tirole, quote, polluted through considerations that can be dealt with by other proper instruments. The DMRB would be a private, public, self-regulatory board consisting of industry and public members with technical and policy expertise, empowered with the mission to develop and propose market-based, non-discriminatory rules to promote market integrity. This private public makeup of the board would ensure that the DMRB gains the public trust while benefiting from the technical knowledge of market participants. Moreover, this model is the most appropriate approach for the digital market oversight because it would have the flexibility swiftly to adapt to new technological developments and business practices in the digital markets, unlike rigid direct and control, command and control regulation. The board would make decisions based on recommendations of specialized internal committees and advocacy groups, which would assist the board with decision making. The DMRB's substantive rulemaking component could address some concerns raised regarding digital markets that are traditionally captured by antitrust laws or existing forms of regulation in an efficient and nimble way. The substantive rules should address should address categories such as interoperability, self-preferencing, non-discrimination, and data portability that would all foster greater innovation and consumer choice. These rules would be proposed for limited review and endorsement by a government body, such as the Department of Justice. This model may prove to be a workable medium between full government regulation on one spectrum and suboptimal self-regulation on the other. Command and control regulation is ill-suited for markets that feature great dynamism as technologies and business practices evolve rapidly. And self-regulation often results in economic free-riding by competitors who engage in non-compliance. Without hindering the dynamism of digital markets with static, burdensome regulation, the DMRB can address many concerns of the market power of dominant platforms. Often in my tenure here, I have channeled the wisdom of former Assistant Attorney General and Supreme Court Justice Robert Jackson. He is no less appropriate today on my last day in office. In 1937, Jackson cautioned us that, quote, American business must make up its mind, whether it favors the regulation by competition contemplated by antitrust laws, or the only probable alternative, government control, close quote. I truly believe that the more we do today to improve the fitness of the antitrust laws and its administration and issues of market integrity, the more we can and should minimize the need for direct command and control regulation by the government. But there is some wisdom, I suggest, to add to Jackson's, informed by what I have witnessed these last years and days. American policymakers must make up their mind whether they favor a Magna Carta or free enterprise on the internet, or the only probable alternative, reactionary and chaotic responses undirected by elected representatives. I hope that these sensible antitrust reforms and the concept for the Digital Markets Rulemaking Board provide a positive path forward. I thank you, Matt, and thank you for your consideration and attention, and I look forward to any comments or questions you might have.
Thank you so much for those remarks, Assistant Attorney General Delrahim. Let's take some questions from the audience. So the first one that we have is from Avery Gardner, the General Counsel of the Center on Democracy and Technology. She asks, are the courts ready to handle Section 2 challenges like the case that the department brought against Google? Or do you think Congress should consider changes to abusive monopoly power law?
That's a great question. Avery has been a champion of enforcement, both at the Antitrust Division and now in her perch. I think the courts are able to handle them. The challenge, of course, is, as I mentioned, there might be some generalist judges who may not be prepared, but fortunately, I think we have faced, by and large, many great judges to address this. And I think the two sitting judges in both the Google and Facebook cases are incredibly well-equipped and thoughtful judges on these issues. It is a challenge, though, because you have to, you have to work within the confines of the laws. I think the biggest challenge is the administrability of these types of cases. We just saw that in Google, the trial has been set for September 2023. That's on top of a year and a half of an investigation. And look, Google, like anybody else, deserves its due process rights to challenge the government's assertions and allegations. But to wait 5.5 years for a possible decision and maybe even longer after appeals and other things are done, makes you wonder whether or not there's going to be a lot of harm in that process that it goes unremedied, and also a lot of businesses that lay in the wake that cannot enter because of the market power until it's proven. So I think the DMRB should help address a lot of that by swiftly, without the command and control and some of the staid processes of a regulatory body, might be able to address a lot of these types of harms that we're talking about.
You mentioned the role of judges, so I want to ask a related question from Barack Richmond, who's a professor at Duke Law School. He says that he was struck by your charges to Congress because most people view antitrust law as judge-made law, especially given the need to be sensitive to the particular facts of each case. That, of course, means that good antitrust law relies on the appointment of good judges. Your speech identified a few recent confusing and incorrect decisions, Sabre and Amex, which in your view could be attributed simply to poor judging. So here's Professor Richmond's question. Don't you think the appointment of federal judges should put greater emphasis on developing good antitrust law?
I think it's difficult because, I spent 5.5 years in the Senate Judiciary Committee, and I had a role in the confirmation of judges. I've been on both sides of Pennsylvania Avenue. And so I know that process. It's difficult because there's so many things that, so many issues that are the purview of federal judges that you can't say, well, you're not going to get on the bench because you don't understand, industrial organization economics. And it's not so much that, it's more we need guidance. And I think antitrust has benefited from its flexibility for judge-made common law. That doesn't mean some of the minor changes that I suggest, drawn both on experiences from here, as well as my service in the Senate Judiciary Committee. There are minor changes that could have real significant impact. Businesses will take a look. If you already have 50% of a market, you still place the burden of market definition and proving shares on the government. But if you already have that, you might think twice and still apply the same test, not some amorphous, public interest test, but still apply the substantial lessening competition. Judges know well how to shift burdens of proof of parties, and they know how to address that. And that can work within our current system without doing damage wholesale to what I believe has worked quite well in antitrust law. So the changes that I propose are administrative changes that Article 1 does take up, and there's been a lot of I just mentioned 3 legislation that just passed in this past year that help improve it. So those are minor changes that could still be implemented, but then you address the development of the law still through the typical judicial process. And then I mentioned the specialized court for antitrust, which wouldn't be a specialized technical court, but still from the sitting pool of judges, the Chief Justice selects those who have an interest and a background in it. And it might be all of them. So, it could be all judges have an interest, but some judges say, look, this is great, but I really have no interest in trying to predict the future in this complex area of law and economics. So, I don't want to be part of that. And that is perfectly fine. And I think you can have a rotating panel of district court judges that could help develop a body of law and body of expertise to address these issues much more quickly.
We've got a great question in the Q&A feature about the DMRB, so I want to come back to that in a second. And just a reminder to anyone who's interested in asking a question, please submit it through the Q&A feature, and we'll get to it in a couple of minutes. Before we go back to that, I want to ask a question from Zachary Eanes, a reporter at the Raleigh News and Observer. We are only a few miles from Cary, which is home to Epic Games. Epic filed its own lawsuits this fall against Apple and Google, focused on the app stores. I'm curious about your thoughts on the competitiveness of the app stores and also the role that suits by private plaintiffs like Epic might have on antitrust jurisprudence.
Well, it just depends. I won't comment on any pending litigation, partly because there might be investigations at the department in some of those companies. But as a general matter, you could have cases, and each of those cases will develop law. I mentioned American Express, and that's a case that I was critical of the department, of the division's case in that, because sometimes bad facts and bad cases could make bad law. And Amex is a good example of it. I think given the contours of that case and its setup on the appeal in the Second Circuit, the court struggled to do the best it thought it could do without having a huge impact on new business models. But I think some clarifications, not a wholesale repeal of that case, but clarifications is needed. I think on these platforms, there certainly are issues. Look, you have the policy considerations when you develop a product. Should you be mandated to share that? I've been quite vocal that when you innovate, you should not have a unilateral. You should have the absolute unilateral right to not share it with a competitor. When you're dealing with platforms, and every single one of us have only 2 mechanisms to access through mobile devices, the internet. And because of the pandemic, a lot of us have been doing banking, healthcare, education online. The question is, you have 2 avenues through our mobile phones. It's either the iOS and the Apple Store, or through Android and through the Google's App Store. And regardless of who manufactures the phone, it's either, well, if it's Apple, it's only iOS. And if it's anybody else, you're using Android. So that is a real issue. And should we now begin looking at them in a different way? Should there be some non-discrimination provisions like there have been in other areas where you only have 2 mechanisms by which to reach American consumers and businesses? And I think that's a legitimate issue. And that's something that could really be addressed by the DMRB in a thoughtful way, rather than by a bunch of government bureaucrats, but in partnership with some government policymakers, by real technologists and companies who say, you know what, this benefits all of us. Let's create competition and an enhancement. And I think this is a good time to be really thinking hard about that.
A couple of follow-ups on the digital markets rulemaking board. So the first question I have about it is, how is it similar to or different from some of the other similar proposals for regulatory or quasi-regulatory agencies to address some of the concerns that you might have? So there's a digital markets unit in the UK that's gotten off the ground. There's a similar proposal for an institution in Australia, and then a series of academics and practitioners, Fiona Scott Morton, Gene Kimmelman, Tom Wheeler, Phil Verveer, and others proposed a digital platforms authority, a digital platforms agency. So I'm curious, how do you see what you propose as being similar to or different from theirs? And then Lauren Fainer, a reporter at CNBC, asked, what would the ideal types of members you'd envision serving on the DMRB?
Great question. And we've studied all of them, and I commend, my friends who were the authors of the UK proposal, the study to create that model, which I guess it was called the Furman Report, but former economic advisor to President Obama, and then Philip, who's a professor at Toulouse University and used to run the British Institute of International Comparative Law. Dr. Philip Marston was the co-author of that and a real thoughtful leader in this area. Gene's and Wheeler's and Morton's, Scott Morton's proposal for a new agency. I am trying to avoid a new regulatory agency. I think, like Robert Jackson, we can avoid, Congress steps in when markets are totally broken. And we're getting to that place where we are, and it might create another, Federal Energy Regulatory Commission or Surface Transportation Board or Interstate, Railways Commission or Federal Communications Commission. In my view, those are not the best models to address the types of competitive harms in the digital markets, because business models change. I mean, digital advertising has mutated and changed over the last, just 3 years, multiple times, and how the ad technology is in place and what you do with the business transactions. And the challenge really is, will a government body like the Federal Platform Authority that has been proposed, will they be able to issue rules fast enough and also change them? So the legal operation of how this model will work, and I mentioned the Municipal Securities Rulemaking Board, it's fascinating. Unlike the SEC or other ways, this industry body will come up with rules. So there's the dynamic and leverage to negotiate between the two sides. They will issue the rule. It gets reviewed by a federal body. So it can be reviewed for, antitrust, consumer protection, national security, let's say by the Justice Department. It could be, housed in the Associate Attorney General's office, so that to benefit all of those disciplines. The government, however, cannot, there's going to be negotiation between the two if they want to make it work. So that dynamic will really help improve the rules. But all it could do is deny it for being against the public interest. So it's not a broad public interest test with years of APA litigation in the courts. I mean, look at how many years FCC has tried to put some network neutrality rules and tried to shoehorn them in Telecom Act of 96 and Title II, and it's gone back and forth between the DC Circuit. It's to try to take that out of that and allow for rules to change as soon as business models change and new challenges are raised. So, 10 years ago, 20 years ago, we were worried about, cookies being on your computer and without your consent. And that was one mechanism, but that technology, and there's new mechanisms by which online platforms follow consumers and sell and collect and sell the data. So it's a way to harness both the ingenuity and the expertise of the tech industry. Let me answer Lauren's question. Who would be the types of people? Matt, folks like you, folks, could be from the academia, folks like Gene Kimmelman, but then also technologists within the companies themselves. So I'm sure there's fantastic engineering geniuses and data scientists at Google, could be at Facebook, but they won't control what happens to the industry. It's going to be a group of people who know this, and the idea would be that the agency wouldn't be captured like regulatory industries are captured by the biggest players because they have the money and the political power to appoint the leaders and the commissioners. This is different.
The next question we have is from Cecilia Kang of the New York Times. You mentioned events of the past few weeks that highlighted the power of digital platforms. Can you talk about your view on the role of antitrust enforcement in speech?
Well, I have talked about it in the past. I think the more competition you have between platforms, then the more you could have qualitative analysis, and that includes privacy. That includes the ability to speak in different platforms. Maybe Cecilia is referring to Twitter and a competitor like Parler. And again, putting inciting violence and any kinds of hate crimes aside, we're facing a major public policy debate here about censorship, not so much by government, which would be obviously controlled by the First Amendment and the 14th Amendment, but a handful of private actors. And I think our founding fathers and the authors of the Sherman Act, I don't think they wanted us controlled either by the government or by a handful of private industry folks, which is what led to the Sherman Acts and being enacted in the first place in 1890. So those concerns, whether or not the concerns we're talking about fit squarely in antitrust law, or there's a market shift and market failure that antitrust didn't address earlier, we might have to address them with other types of policy solutions. And the DMRB could be a perfect model to allow for that. Given its government involvement, I think somebody would have to think about the First Amendment implications of government dictating or limiting speech. But I think if it's carefully crafted to limit, hateful or insightful speech that isn't covered by the First Amendment, the industry could come up with its own body.
I think we have time for one or two more questions. So one from Mike Liverite. He asked, what about large firms whose mergers would have violated the new laws? Is there a way to roll back such mergers?
I think certainly there is a way to do that. Congress could make some of these civil laws. I don't know if that's the right approach to retroactively go back, because it would cause uncertainty. But depending on what those standards are, Congress, I believe, has the power to be able to apply that retroactively. Whether or not that's wise, I think it's something that should be considered. And again, I don't pretend to be the smartest person in the room and I have the silver bullet, but it's one where Congress is going to think about this. And these are bipartisan issues that is really important at a critical time for all of us. Innovators and users of technology and businesses. And I think businesses by and large would like to have certainty about what can they do. Give us some bright lines, not some fuzzy lines. And I think a model like that could provide that.
The last question I'll ask goes back to the DMRB. So I'm curious about how you see the DMRB playing a role in data access, particularly for researchers. So that's been a hot issue over the last few months in the last several years, with researchers wanting access to data from platforms that they believe will help them study social issues related to platforms or study the markets themselves. And then platforms sometimes are hesitant to provide access to data, at least in part because of liability concerns related to data transfer to researchers. I'm curious how you would perceive the DMRB addressing that issue? Would access to data for researchers be part of the value proposition of the DMRB?
To be honest with you, it's not something where I have given that thought for the research purposes. Of course, the government could provide such access. We do that if it's for health and safety. You have access to data, the pharmaceutical area, where the government and some researchers could get access. The issue of data and privacy is a critical, different issue for Congress that needs to address. Do we have property rights into our data that's collected by companies? Should we? And that's a really important policy discussion, and I hope Congress has in a thoughtful manner and addresses that. Should data that is collected. Now, I do have to give some caution because companies who invest in collecting data, assuming they do it properly. And again, this regime of whether or not they should ask you, I'm a big fan that the companies should have an opt-in. They should ask me if I should get that information. Obviously, if there's a disparity in market power and I need some access, I just give it up by clicking consent. But at a minimum, it should not be just taken from you. And I think this debate between Facebook and Apple in public is fascinating to me because Apple is just trying to, at least it seems, with the new iOS upgrade, give the consumer the power to protect the level of privacy it expects. So the app developers need to ask. I think that's sensible. And in fact, Congress could, implement exactly that policy for all platforms. And I think that would be, a positive move for consumers. But one thing I do want to give some, express a little bit of caution is that if companies invest, there could be a small company who invests in collecting data and they improve the offering and the products using machine learning, which is fascinating because it could provide a lot of efficiencies, whether it's in the legal profession or in marketing or in supply chain management. That is critical. And the time and money and efforts that they have invested in collecting the data should not just be forced to be shared with a competitor. That is a really important element and a balance that we must think, because it would reduce the incentive to do that, which would lead to consumer harms that I think, as a matter of policy, would do probably more bad than good. Now, if it's there's certain platforms that now have reached market power, and whether or not you should have access to them, I think that is similar to the way we used to think about AT&T and whether or not long distance should connect to the local, or remember a long time AT&T was preventing you from buying your own phone and tapping it into your wall because they said it would disrupt their network, and you had to lease for $5 a month the phone from them. And Congress, stepped in, said no, and it created a lot of new innovation. And I think we might be getting to a place where we should think about some of the larger platforms, whether or not you should have considered mandatory access to them, or non-discriminatory access to them, making sure that data security and privacy considerations are factored in. So it's an area we have addressed in the past, and I think it's going to be an important area to address in the future.
With that, thank you to everyone on the live stream for joining us today, and thanks Assistant Attorney General Delrahim for joining us on your final day in office. Best of luck in the transition ahead.
Thank you so much, Matt. I really appreciate it. And thank you to the folks who tuned in and asked those excellent questions.